Welcome aboard, applicants. I thought we would begin today with the October 2020 California Performance Test Part 1. We're going to walk through the framework of how to put together this in terms of a structure of the PT. And then we'll go through and fill out more of the details later on in the different parts of our California PT from the October 2020. When so let's start with the first thing, okay, which is when we're given the October 2020, we get the performance instructions and file. So let's read. Our first page would be potential right litigation. We have our instruction page, and we got our file. Now, in the file, there's the memorandum to applicant from Marjorie Turner, memorandum to file regarding potential right litigation, and then letter regarding unauthorized charges. So we have a pretty good layout now of what our file consists of. Okay. Now let's continue to go through here in our performance test instructions, reading through our instructions, and you can read through those. We want to make sure to establish the jurisdiction we're in is in the state of Columbia. Okay. And going now to our memorandum here, which is our letter to the associate, we come down here and we look at the task. Okay. Now, where our senior partner is saying, I have already determined that Ryan was able to and did in fact enter into a contract with GamerTracks so that I may discuss this matter with Janice. Please prepare a memorandum that answers the following questions. Is Ryan able to disaffirm the contract? One word we want to pick out of this, as it already stands out to me, is the word disaffirm. And then two, if so, did Janice's letter, again, there's another same term, disaffirm the contract for Ryan. And then three, is Janice liable? Well, excuse me, thank you. Is Janice liable for the $8,980 charge? Now, do not include a statement of facts in your memorandum, but do use the facts in its body. Okay. Now, before I even began the structure, I would also now just read my introductory facts. Okay. First, I would start from the top. Memorandum to applicant, that would be us, from Marjorie Turner, that would be our senior partner. Date October 6, 2020, and regarding potential right litigation. Now, Janice Wright, a longtime client, has retained us on a matter concerning unauthorized credit card charges ran up by her son Ryan for online purchases connected to an online video game website called GamerTracks. At Ryan's request, Janice gave him permission to open an account using her credit card. She told him he would charge no more, or she told him he could charge no more than $20. He ended up charging $9,000. After receiving her credit card bill, she sent a letter to GamerTracks asking for reversal of the $8,980 charge, but GamerTracks declined. She would like our help in determining whether she can avoid paying some or all the charges. And again, we repeat our task down here. So let's start setting up our paper. We want to make sure to put our two, and our two here is going to be to our senior partner, which is going to be Marjorie Turner. Okay, from, that would be us. Okay, and then we're going to be regarding, or I should say, excuse me, date. That'd be October 6th, 2020. And then regarding, I'm going to come down here and do this, regarding potential right litigation. Okay, and also too, make sure these, and just bring this just like that. Okay, and then also we want to make sure to put our conclusion here ahead of time so we don't forget in the exam conditions. Okay, we want to make sure respectfully submitted, applicant. Okay, then we want to make sure to bring this up here just like that. Okay, now also we're going to address the task questions, or the task problems, I should say. Number one, is Ryan able to disaffirm the contract? Question mark. Two, if so, did Janice's letter disaffirm the contract for Ryan? Make sure all this is we don't capitalize more than what we need here. Okay. Thank you so much for your patience with me. Okay. And then number three, is Janice liable for the $8,980 charge? Question mark. Okay. Now we can start opening these up and start filling them out with our issues that we would bring up. Okay. Now, we want to make sure to have a little introductory paragraph or two or a paragraph that would indicate to our senior partner what facts we're dealing with and the task that we're answering. So we'll put a little asterisk there. We'll fill that in. I'll put an introductory statement, and we'll fill that in another part. But we want to make sure that we don't forget to put that in there. Okay. Now, also too, we want to make sure down here we don't forget to put in a conclusion, which would be very nice, so that we can conclude as to 1, 2, and 3. Not only are we going to conclude as to 1, 2, and 3 individually, but collectively we could conclude as to the entire task. Okay, now reading through here, now that we know our background facts, we're going to quickly read through the file to get basically a big bird's eye perspective as to what it is we're dealing with in terms of facts. Okay. So we got memorandum file, Marjorie Turner, September 29th, 2020, potential right litigation. First sentence paragraph. I met with longtime client Janice Wright yesterday to discuss a matter involving online video game activity by her 12-year-old son Ryan. Let's give us some background facts concerning Ryan. The GamerTrax website allows users to play a wide variety of online video games for free. The GamerTrax website also allows users to buy certain options to enhance their online video game experience. And then 2 months ago, at Ryan's request, Janice gave Ryan permission to open a GamerTrax Treasure account using her credit card. Ryan opened a GamerTrax Treasure account, and then here's it seems that we have our the agreement, which is 1, 2, 3, and 4. GamerTrax contacted Janice, and she verified she had given Ryan permission. After opening the GamerTrax Treasure account, Ryan started playing an online game called Galaxy. Oh, thank you for your patience. Galaxy Odyssey, and obtained a few options. Then further down, when Janice received her credit card bill, she sent a letter to GamerTrax asking for reversal of the $8,980 charge. Okay, and then Janice has not yet paid her credit card bill, pending consultation with us. Now, that would be the document concerning potential right litigation. Just a quick skim read there, and then Miss Janice Wright. This is her letter to GamerTrax, September 21st, 2020. GamerTrax, all this, the GamerTrax location. Regarding unauthorized charges, dear sir, ma'am, I'm writing a request that you reverse the amount of $8,900 for unauthorized charges to my credit card. Okay, and then thank you for your prompt attention to this matter. Very truly yours, Janice Wright. Okay, so right now we don't really know what are the material versus the not so material facts until we get to our what are our issues. Okay, so let's get down here to our library. Now, in our library table of contents, we have, in regard to potential right litigation, library selected provisions of Columbia Civil Code, selected provisions of the Columbia Family Code, Miller v. Miller, Columbia Court of Appeals, 1963. Brady versus Thomas, Columbia Court of Appeals, 2004. And Laredo versus Purcell Fruit Co., Columbia Supreme Court, 1950. So, if this were a determination of one particular issue, definitely the Supreme Court decision would sit supreme. So let's continue to go down here. Now select provisions of the Columbia Civil Code. Now right at this point we're reading the headers here. Selection 3800 agency defined, 3801 or sorry 3801 actual authority, 3802 apparent authority, creation of actual authority, creation of apparent authority, binding effect. Okay. Now we don't know exactly too. We know that this is there, but we don't know which of them are material in terms of our issue. Now the select provisions of the Columbia Family Code here, just quickly going through selection 6701, minors power to contract, minors power to disaffirm, and exception of minors power to disaffirm. Now we're getting into Miller. Okay, good. Now, in terms of Miller, now this is, we're going to also quickly skim through this. By his complaint, Bryce Miller sought judgment against his mother, Josephine Miller, for $26,000, representing payments issued to him when he was under 18 years of age under a contract of employment as an actor. Okay. Nothing else indicates that we only have facts here at this point. We will come back to those in another part of our podcast, our podcast set of parts. Bryce was born March 11th, 1940. In 1953, Bryce entered into a contract with Couch Studios, Inc. to portray a role in television series. Still looks like more just background facts concerning the Miller v. Miller case. Now, by this action, Bryce seeks to recover the $26,000 received by Josephine. Now, remember, we're skimming through here, and we see this popping out right here. So we know that the Family Code section 6703 goes right to Miller. Okay. Now stood in the way. Now remember here, what is it about the Family Code that stood in the way? That up here, let's just quickly skim back up here. This is an exception, the minor's power to disaffirm. So we're looking here at, we could think about this in terms of Ryan's power to disaffirm, or we could see this as part of Janice's letter to disaffirm. I would probably see this more as Janice's letter to disaffirm. So I would probably pair the Miller v. Miller case, or just throw in Miller, and bring in right before, probably with this, I'd probably say section 6703. Okay. So now I'm starting to build my structure here. Now, in entering judgment for Josephine, the trial court found that she expended the $26,000 she had received for herself and for Bryce. Now, they also they want us to read this too because it's in italics here. For things necessary for their support. Okay. And versus, and then in quotation here, good things of life, not necessities. Okay. Keeping that in mind when we go through the Janice part of our analysis, we're going to be bringing up Miller in section 6703, and then down here under Brady. Now Martha Thomas and her minor son Craig Thomas appealed the judgment in favor of Craig's former personal manager Sharon Brady for unpaid commissions under a contract. Okay, in 1999, Brady entered into an artist manager's contract with Martha and Craig, who was then 10 years old. Okay, nothing here. I'm not seeing any code or any particular test or factors here. Now, in 2001, Craig obtained a recurring role or acting role on the Acme television network show The Go-Kart Kid. Nothing really here. These are just mainly going to be at this point supporting facts for later discussion underneath are what we're setting up in terms of our structure. Okay. Now, again, still, I'm not seeing any particular code or factors here, more just facts. And okay, now as a general proposition, This is where we're going to get into. Parental consent is required for the provision services to minors for the simple reason that minors may disaffirm their own contracts. To acquire such services. I'm already starting to see that Brady could very well go with Ryan here because of this. And then we want to make sure to put, because Brady does talk about right here, Columbia Family Code, voila, 6701. And we want to make sure too that Columbia Family Code right here, okay, section 6701. Okay, and then come up here. Does Brady bring up more family code provisions? Absolutely, right here. The other one is the 6702. Okay. Okay. Now, also let's skim through here again, going through and making sure that we're not missing any other particular issues to be brought up. Doesn't look like that. Making sure too that see no specific language is required to communicate an intent to disaffirm a minor's contract. This paragraph looks like we could use this as further argument. So we'll keep that in mind. Now coming down here to Laredo now. Now Linda Laredo brought an action for breach of contract against Purcell Fruit Co. in her complaint. Laredo alleged that she had entered into a contract with Purcell, represented by its agent Henry Hand, to sell a crop of oranges for $30,000. Now, going down here, doesn't look like there's anything but facts here as well, just getting a background. Purcell's theory at trial and on appeal is that Hand did not have actual authority. Where have we seen that? We kind of come up back to our code, and that would be our civil code if I remember correctly. That's right. Agency. There we go. Actual authority, apparent authority. Okay. Now we get what Laredo's talking about here. Now down here, actual authority, and not only that, guess what? They bring up the Columbia Civil Code, section 3801. So let's put that down here underneath. Is Janice liable for the $8,980 charge? Section 3801. Make sure to bring up Laredo. Okay. Now, is there additional Columbia Civil Code sections that are brought up here? Absolutely. Look right here. It's Columbia Civil Code through 3802. Now, in contrast, Laredo's theory at trial and on appeal is that at the very least, Hand had the apparent authority, to make the contract of sale. So this, we want to make sure too that we're putting these together correctly for our discussion. Because remember, 3801 deals with actual authority. And the Columbia Civil Code, section 3802, deals with apparent authority. Okay. Now, going through here, now Laredo's theory prevailed below. It prevails here as well. So we know that the Laredo theory is the one that prevailed, and this paragraph here would supply additional argumentation when we come back and help parse or build up our outline here. Okay. Now I don't see anything else besides that, so let's come up here. Also, let's come up now. Now that we know our tentative outline, we're going to come up and add some more detail to this as well. Now our 3801 actual authority. It actually does have, let's see, this is the family code. Thank you for your patience. Right up here, under the 3801, there's 3803 at creation of actual authority. We should pair these together. So Columbia Code section 3803 goes with the 3801. Now 3802, remember, goes with Columbia Civil Code section, and down here, right here on the next page here, creation of apparent authority, 3804. Okay, and remember too, we want to make sure that the binding effect the fact that the three asterisks here, the new thought aspect goes with each of these. So right here, we want to put in Columbia Code section 3810 and Columbia Code section 3810. Make sure to bring in Laredo for how Laredo talks about these as well underneath each one of these discussions here. So we want to make sure that we bring in, okay, for actual authority, okay, and then underneath here we have apparent authority, okay, and then underneath the Janus are the letter to disaffirm that Janus's letter, because for Ryan, when we come back and we talk about Miller, we want to make sure that we're talking about, excuse me, thank you for your patience, just scanning through here to get back down to 6703, right here, exception to powers to disaffirm. So we're talking about power to disaffirm. And okay, power to disaffirm, and I want to make sure that we couple this with the CFC section. We're going to borrow this from up underneath Ryan, okay, because this deals with the adult's power to disaffirm, and this one up here would deal with the child's power, or the minor's power to disaffirm. Can we now here is exceptions to minor's power to disaffirm. Okay, and that would be our header for that one. Okay, up here though, I want to make sure that we bring up minor's power to disaffirm. Okay, and I think at this point we've got to start in the right direction. We'll be filling this out later on in parts to come for our PT. And so right now we're just going to put a bookmark right here, and also we don't, the bookmark too goes with this. We want to make sure that as we're doing these, we're also formatting these as well. That we're bolding and underlining our headers. Okay, so that these are drawn in. Or to say this, that when our readers are reading through our PTs, that they're able to clearly see what point we're trying to prove when we bring up our rules, and we support the elements from those rules with facts, so that when it logically goes to proving a clearly indicated issue. So okay, with that, then like I said, we should probably put a bookmark right here, and we'll call this part 1. I want to put a shout out to Chess Cruncher TV. Keep chess crunching, Chess Cruncher. I want to put a shout out to my Amazon Kindle book, Battling the Big Bad Baby Bar, Essay Basics. Thank you for tuning in, and God bless.